Welcome to today's program titled Changes Coming to the California Consumer Privacy Act, What You Need to Know. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you received recently. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to our first speaker. Kathleen, you may begin.
Good morning or good afternoon, depending on where you are. Thank you all for joining us today for our CCPA Updates webinar. I am Kathleen McConnell. I'm a partner here in San Francisco. I am one of the leads in our global data privacy and cybersecurity group. Most of my practice really kind of relates to compliance setup, compliance program setup, and counseling. Last couple of years, I've also been dealing a lot with the California Invasion of Privacy Act litigation and also counseling in that space. I also head up our data science team. We have a team of data scientists where we do a lot of data quantification and visualization, both in litigation and counseling space, as well as a handful of other things. I'm going to turn it over to Yana to introduce herself.
Hi, everyone. I'm Yana Konsitsky. I'm senior counsel in our Los Angeles office, and I sit in our international practice group and integrate California CCPA privacy compliance into our global privacy practice and global privacy framework build out.
I'm Danny Riley. I'm an associate out of our Chicago office. I sit with commercial litigation, and I focus mostly on privacy, cybersecurity, and information governance matters, with a bit of litigation and consumer class action work.
And I will briefly introduce Vince, who should be joining us shortly. Vince Smolchinsky is counsel in our Charlotte office, has an IP background by trade, and also does a lot of compliance program setup, and again, also a fair amount of California Invasion of Privacy Act, both litigation and counseling the last couple of years. And hopefully his internet connection issues will be resolved and he'll be joining us shortly. So to touch briefly on what we're planning to cover today, there have been, as probably most of you are aware, a significant number of additions, revisions, and changes to the California Consumer Privacy Act regulations that are going to be going into effect starting in January of 2026, with a rollout kind of depending on what section of the regs we're talking about for enforcement. So we're going to touch generally today on the compliance timeline and the general updates to the regs. Then we're going to talk in more detail about automated decision-making technology, followed by touching on the brand new category of risk assessments. We're going to get into cybersecurity audit requirements, which are really fairly extensive in addition to the risk assessments. And then lastly, we're going to touch on both CCPA and California Invasion of Privacy Act consent management matters, considerations around both, the similarities and the differences between the two, and kind of how to best mitigate risk in that area generally. Also touching on kind of do not sell issues more generally in that section as well. And then we're going to wrap up by talking about preparing your business for the future. And since Vince is back and hopefully has audio, I will let him do a brief introduction for himself if he can.
Hi, everyone. Vince Smolchinsky from the Charlotte office of Seyfarth Shaw. My practice focuses on data privacy issues as well as intellectual property. And I will put myself back on mute here until I'm ready to go. Thank you.
Great. If we can move to the next slide. Excellent. So as I touched on briefly, the regs have a significant number of entirely new areas in terms of risk assessments, ADMT enforcement and regulations, and cybersecurity audits. Those three big sections are going to kind of roll out with various implementation dates that we'll get into more detail with as we roll into those sections. There were also a number of more general updates that are not as heavy of a lift to get into, but those will start going into effect in January of 2026. So a little bit more immediate in terms of compliance deadline there. So in terms of timing to be thinking about for what does your company need to be doing now to prepare. Currently, here in 2025, it's definitely going to be helpful to start thinking about processing activities and tools that may trigger risk assessment or ADMT obligations. You want to start thinking about drafting pre-use notices for ADMT and start working on mapping your data flows. Risk assessment implementation really starts going into effect in 2026. 2027, we start dealing more with ADMT enforcement, and 2028 really starts seeing reporting requirements for your cybersecurity audits. All of these things, however, require a fair amount of ramp up and ground laying work that needs to be done in order to complete them. So you don't want to be thinking, the cybersecurity reporting is until 2028. You don't want to start thinking about it in 2028 because it's going to require a fair amount of lead up work. So jumping into kind of the general updates that are going to be going into effect in 2026. Next slide. One of the areas that was updated with these regs is that for privacy policies, the requirement of what needs to be disclosed in terms of categories of documents have been updated to include both service providers and contractors in addition to third parties. So previously there were more specific requirements about what categories of documents what categories of information that was disclosed to third parties needing to be disclosed in your privacy policy. But the revised rules really remove any ambiguity that the privacy policy also needs to identify any categories of personal information that are disclosed to service providers or contractors for business purposes within the preceding 12 months. If you're not disclosing information, I can't imagine anybody falls into this category, but if you're not disclosing information to service providers or contractors, there's also now a requirement to add that, to address that in the privacy policy as well. Another category of things that have changed with the regs is that there is clarification around the access requests. So for a business that maintains personal information of a customer for longer than 12 months, which for most of us, most of our businesses is the case, the consumer request mechanism must now include a means by which your consumer can request access to personal information collected prior to the 12-month period preceding the consumer's request. There's a couple different ways to do that. You can either have them just kind of indicate that they want everything, or they can indicate a particular date range for which they are making the request. Another one of these smaller changes, but has the more immediate impact, is with respect to mobile applications. Mobile applications previously had the option to include a link to the privacy policy in the application setting menu. And that permissive requirement has now changed to a mandatory requirement. So for those of you that have, mobile app offerings, you now need to make sure that you've got a link to the privacy in the application settings menu. It's no longer an optional choice. Tucking into kind of the overall push towards kind of symmetry and balance in choices, one of the other changes with the regs are that financial incentive programs may not be selected by default. So if you have a financial incentive program, you need to either default it to opt out, or you can leave both boxes unchecked and let the person make a proactive choice there. But it's not going to be considered kind of symmetrical and balanced anymore to select a consumer's participation into the program by default, or to feature an opt-in to such a program more prominently than the choice not to participate in it. And you'll see that concept come up a little bit more when we're talking about consent management more broadly, both respect to cookies and kind of do not sell, do not share issues. But it's a theme here with the financial incentives as well. All right, another change with the regs that's going into effect pretty quickly here in 2026 are that for connected devices, the regs have really clarified that the connected devices, you need to provide an opt-out in the same manner as which you're collecting the data, and that it needs to be before or at the time of collection. This also applies for companies that are providing AR interactions and options. The data collection, again, needs to be provided there in the same manner. Sorry, the opt-out needs to be provided there in the same manner that you're providing the data collection, and it needs to be at or before the point at which data starts being collected for those connected devices and for those AV/AR type interactions. Other changes for 2026. Sensitive data received a number of updates in terms of the scope. A couple of specific things that changed there are that neural data is now defined as part of sensitive data. And in addition to that, actual knowledge that individuals under 16 are having their data collected is now a category that falls under sensitive data. Curiously as well, or importantly as well, sensitive data now includes the content of messages. So text messages, emails, chat type messages, unless the person receiving the message is the intended recipient. So this has some impact in terms of what companies can monitor in terms of incoming and outgoing messages and the purposes for which they are allowed to be monitored. So for instance, there are things that you can do to monitor for security or trade secrets, but if you were doing monitoring for other reasons, that might not be permitted. All right, and then another clarification is that for insurance companies, and I know we do have a number of insurance companies that are active in ways that are relevant in this space. The regs clarify that the partial exemption is limited to data that is governed by the insurance code. So if you are collecting data for, advertising or marketing purposes, insurance companies are going to be subject to CCPA for that data that is not covered by the insurance code. Kind of similar to some of our other industry-specific exemptions. It's really only the data that's covered by those other regulations that are exempted. All right, and then we are going to get in more detail into opt-out confirmation, GPC signals, and consent management later in the program, but just know that there are updates that are affecting those areas as well. And I'm going to turn it over from here to Danny to talk about automated decision-making technology.
Thanks, Kathleen. So shifting gears to the part of the regulations that gets a lot of attention. This is kind of California stepping into the automation AI space. And while the rules don't really ban anything with respect to these tools, they're starting to bring up the idea of transparency and documentation. So let's jump into it. Let's jump to the next slide. So the first thing we need to do is simply define what ADMT is. At a high level, ADMT covers any technology that processes personal information and uses computation to substantially replace or to fully replace human decision-making. So that basically means if the tool is producing an output that your team relies on instead of a human reviewing all of the relevant information and making their own determination, that's ADMT. And the regulations go a bit further by laying out what meaningful human involvement actually looks like. To count as meaningful human involvement, someone reviewing the outputs need to understand how to interpret a tool's output. They need to actually review and analyze that output and any other relevant information. And most importantly, they need to have the authority to change the decision that the tool is putting out there. So if a person is just rubber stamping whatever a tool spits out, that's not human involvement, and the CCPA will treat that as ADMT. So these rules apply anytime ADMT is used to make what the regulations call a significant decision about a consumer. Think of all of the big life impacting categories here: employment, education, access to financial services, and housing. Essentially, if your tool is influencing or automating decisions about those categories, these obligations kick in. And importantly, and Kathleen kind of touched on this, the regulations will be enforced in 2027, but it's not so far away. There's a lot of prep work that needs to be done ahead of time and now and in 2026, such as taking inventory of the tools that your business is using, mapping data flows. So basically, the runway is a bit shorter than it looks for these tools. Jumping into the next slide with our first big requirement, and that's transparency, specifically a pre-use notice. This is not entirely a new concept in California or in many states governing privacy. So under the CCPA, businesses already need to have a notice before or at the collection of personal information. The regulations here are basically saying if you're going to use ADMT, that needs to be disclosed too. You need to explain why you're using it, how the technology will affect the consumer. And then it follows really the other regulations. It needs to be readable and understandable and clear. I think something that's helpful here is that this pre-use notice can be added to your existing notice at collection. So it can all be in one place for transparency. Moving on to consumers' right to access ADMT. So once the business is making significant decisions, consumers kind of gain this new right to understand how this technology is being used. And it's not really a standard right to access personal information. This is kind of an explainability focused right. The idea is that if an algorithm or automated process is used, you need to be able to explain it. And to be able to explain it, you really need to understand the tools you're using or you're hiring vendors to use. So when a consumer exercises this right, you need to talk about the specific purpose, what decision was being made by the ADMT, what categories of data went in, and at a high level, how that data is used, the output, and how that output affected the significant decision, and then layering in language about how the consumer won't be retaliated against for exercising this right, which is pretty consistent with the other privacy rights. One important nuance here is while businesses need to provide this meaningful information, it doesn't necessarily mean you need to be disclosing trade secrets or proprietary models. The expectation is clarity, not necessarily source code and everything going on behind the scenes. So moving on to the next consumer right, the right to opt out. This is when a business or when a consumer can step in and say, no, I don't want this automated tool making this call about me. And practically, it means that businesses need to kind of build an off-ramp for consumers. So a few key things to highlight here. Consumers must be told about this right upfront in the pre-use notice. It can't be buried in a privacy policy. It has to be clearly called out that they have the right to opt out. Second, you need to offer at least two methods to opt out. This is consistent with other opt-out rights under the CCPA. It's nothing really new. And third, the process needs to be simple and accessible. Once again, nothing really new. Fourth, though, once the consumer opts out, the business has to honor that quickly. And there will be some discussion about this later, but I think it's worth noting that a lot of the regulatory investigations now are not so much into the transparency and kind of what you say you're doing for consumers. A lot of the attention comes down to how that's actually working, the operation behind it. So making sure you have kind of everything in order to be able to respond quickly and within the timeline set out in the regs is very important. Now, there are situations here where a business does not need to offer an opt-out. So if we look at the exceptions here on the next slide, first, when a consumer can appeal the ADMT-driven decision to a human reviewer, there's an exception. If a real person with real authority can meaningfully review and change an outcome, then the consumer doesn't need the ability to opt out up front. This is kind of a safeguard that functions as a check. Second and third, and this is kind of an interesting exception, businesses can avoid offering an opt-out for admission, acceptance, or hiring decisions in education or employment. And they can also use ADMT to assign work or determine compensation. And businesses do not have to offer an opt-out in these situations as long as the ADMT is extremely siloed for that specific purpose. It needs to be solely intended for that purpose. And of course, unsurprisingly, it cannot unlawfully discriminate based on protected characteristics. So that's pretty much ADMT right now at a high level. I think if we go to the next slide and talk about kind of a high level to-do list of how businesses should prepare now, and you'll see a lot of these overlap with the other regulations and kind of what you need to be doing to prepare over the next few years with all of these new requirements. So I think the first step here is identifying what tools you're using, both internally and through vendors. You need to understand what you have so that you can start to address those. Next would be start drafting your notices, updating your data access right processes so you can respond efficiently and the business is prepared to comply or potentially deny consumer requests where legally allowed.
And I think it's one thing that's probably worth mentioning too is with respect to identifying, your tools that are ADMT or that use AI components, this requires some level of education for your personnel, because what we often find is that the legal department doesn't necessarily know all the tools that the various departments are using across the hiring, employment, employee management process. And so that can often require a fair bit of investigative work. And something that comes up not infrequently is that someone who's using a tool might not realize that it has an ADMT component or that it's got an AI feature to it. And so we found that you need to be a little bit more thorough, I suppose, and kind of educational as you're having these discussions with people about what tools are they using, what ways are they using them in, because your user who's using it may not realize the ADMT or the AI component of it necessarily. Sorry for
thanks, Kathleen. I totally agreed, and I think it also speaks to the broader AI tool landscape. That these tools are cheap, they're easy to use, and it's easy for kind of shadow AI to come up with personnel using generative AI or AI note takers. And so really taking stock of everything in your governance program and looking at what tools are we allowing, what do we have control over, and what policies do we have in place to make sure, to the extent possible, we are managing this and kind of staying ahead of some of the issues. I think with AI right now, while regulations are coming, there's still ways that AI use is creating legal risk now with unfair and deceptive practices, wiretapping laws, privacy laws, and businesses also want to be able to protect their trade secrets, their IP. So there are tons of risks that come up with AI tools. So I think the overarching goal right now is to check in and figure out how are we managing these tools. And now I'm going to transition over to Jana to talk about the risk assessments. But one interesting thing about ADMT is, well, some of these consumer-facing requirements don't go into place until 2027. Using ADMT still is considered high-risk processing. And because of that, that needs to be considered with the risk assessment requirements. So one thing I'll leave the group with on ADMT is 2026 is the governance year. Start your risk assessments, your internal controls, take stock of what tools you're using. And then in 2027, that's when it's consumer facing with your notices, your access rights, your opt-out rights, things like that. So with that framework in mind, I'll turn it over to Jana to walk through the risk assessment requirements.
Thanks, Danny, for that excellent foreshadowing of what's on our doorstep. So that is right. The risk assessment obligation starts January 1st, essentially a few weeks from now. Next slide. So as Danny said, risk assessments are required if processing presents a significant risk to consumer privacy. And helpfully, the regs have told us what that is. So significant risk is created when there's selling or sharing of personal information, processing of sensitive personal information, and there's a narrow exception for this in the strict employment contractor context for payment and benefits, work authorization, accommodations, and wage reporting. And it's important to note that that's much narrower than any prior employment exception we enjoyed under CCPA. Another significant risk activity is using ADMT for a significant decision, as Danny just covered, using automated processing to essentially profile based on systematic observation of an educational or job applicant, student or employee, or independent contractor, or based on presence in a sensitive location. When we talk about profiling, this really is, first of all, in a sensitive location, we do not include a business using a consumer's PI solely to deliver goods or to provide transportation for that consumer at a sensitive location. And sensitive locations are like health locations or several other enumerated locations. Profiling is using automated processing to infer or extrapolate intelligence, ability, aptitude, work performance, economic situation, health, mental health, personal preferences, interests, reliability, predispositions, behavior, location, or movements based on those two things. Another is processing PI to train an ADMT for a significant decision on a consumer, or to train facial recognition, emotion recognition, or other technology that verifies identity or profiles. Next slide. So the regs provide some examples, and those are where a business will use emotion recognition technology without human involvement to make a hiring decision. That is ADMT for a significant decision, of course. A dating app that will disclose precise geolocation, ethnicity, and medical info on individuals that have provided that information in their dating profiles, and where the dating app is disclosing that to a third-party analytics service provider, that's sensitive data processing. A budgeting app proposes to display ads for payday loans on different websites based on evaluation of the financial information that consumers have entered into it. And this is sharing of personal information. And where a tech company will train its special facial recognition technology on consumer photos, and that's using personal information to train ADMT. And the next slide. So interestingly, the goals are stated in the regulations as the goal of a risk assessment is to restrict or prohibit processing if the risks to consumer privacy outweigh the benefits of the processing to the consumer, the business, other stakeholders, and the public. And so when developing your risk assessment, you'll be looking at ways to overcome this in order to be able to proceed and not find yourself restricted or prohibited from processing. I find the image here reminds me of a toilet paper roll, which somehow seems relevant. Next slide. So what does your risk assessment report cover? The regs are specific about the level of detail. So where we discuss the processing purpose in the report, we must not be generic. So we don't say the purpose is for security purposes or process improvement or service improvement. What we could say in that case is we're processing this or this particular activity is intended to decrease wait time when processing consumer rights requests. And generally that sets in the regulations a level of expectation as to the amount of detail that should be carried throughout the risk assessment. So where in the past we have maybe undertaken risk assessments or privacy impact assessments in other scenarios and have been a bit more general, here we were forced to really extrapolate what we're processing and why. Another thing that must be included, of course, the categories of personal information and sensitive personal information processed. And we have to identify and describe the operational requirements to be implemented. So that includes the planned method for processing and the sources of our personal information, how long we're going to retain that personal information, and if we don't know how long, the criteria to be used to determine retention, which is a familiar requirement. The method of interacting with consumers, for instance, on websites or apps, and the purpose of that interaction, the approximate number of consumers that the activity will impact, the disclosures that we are making concerning the processing, including the broader disclosures that we've touched on earlier in this presentation. The names or categories of third parties and the purposes of any disclosures to those third parties. Next slide. For ADMT, we do need to identify and describe the logic, including assumptions or limitations and output, and how it will be used to make a significant decision. The benefits and negative impacts, including the sources and causes. And so this is the one that goes to the crux of the issue of are we overcoming the risk with our benefit? Some of the negative impacts that are flagged are things like unauthorized use, potential discrimination, impairing control of the individual, economic harms, creating opportunity for harm, and that could be reputational or psychological. Any safeguards to be used to address those negative impacts should be identified. And that could include encryption, access controls, network monitoring. It could be a consultation with experts, either around the technology or security measures, or on these issues in general. we can envision things like data scientists. Decision on processing. So this is where you describe in the report whether, despite what you've described above, you're going to proceed with the activity. Identify the individuals who provide the info, and with the exception of legal counsel. So here you're thinking about where you received or where you obtained the information that you're describing in the report, who provided it and why, and the date of the review and the approval of the processing, and the names and positions of approvers. This has to include an individual with authority over the processing. Next slide. So there is an additional requirement for businesses training ADMT, and that is if you're making ADMT available to another business, that will make a significant decision, or you will make a significant decision concerning consumer. You must provide to that recipient business all facts available that are necessary for the recipient business to conduct its own risk assessment. So this is something to consider on both ends of this, in that we will need to ensure that we are including contractually obligations to cooperate and share for these purposes. Next
I
slide.
will say one thing too that we saw clarified in the regs this time around is really an emphasis that contractors and service providers are obligated to provide information to the company that they're contracted with and enable them to fulfill their obligations under the CCPA. Those obligations were arguably there already, but there's definitely language added that makes that even more clear that they independently have that responsibility. So kind of similar to this concept here of it's not just the individual, the starting business that has these obligations, but kind of all of the pieces that are part of the information workflow, whether it's ADMT data or other personal information data. Each of those parties is really responsible for cooperating with and providing transparency with respect to the processing and disclosure and use of how PII and sensitive personal information is being used.
Yeah, and the amount of information that you have to identify and document in your report is going to necessitate collaboration and education between parties utilizing technology on both ends. Next slide. So what are the timing and frequency requirements? We have to do a risk assessment before any new activity that carries a significant risk as defined. And for any pre-existing activities, helpfully, we have an extended deadline essentially until December 31st of 2027, which accounts for the volume of assessment that needs to be done in identifying your activities that carry significant risk and documenting them in this way. So really, probably not a lot of time and does require getting started as soon as possible. You do need to review and update at least once every 3 years your risk assessment for accuracy or continued accuracy. And you also need to update potentially sooner if there's a material change to the processing. And you have to do that as soon as feasible, but no later than 45 calendar days from the date of the material change. A change is material if it creates new negative impacts or increases the magnitude or likelihood of previously identified negative impacts, or diminishes the effectiveness of the safeguards that you've put in place. And I think that's a really subtle definition where we may not always notice, and your business may not always notice when a material change has occurred in the same way that it is a bit easier to notice in other legislation that refers to material changes requiring updates. Material changes may include changes to the purpose of the processing, the minimum personal information necessary to achieve your purpose, or the risks to consumers' privacy raised by consumers themselves. And a specific example that's given here is that in cases where numerous consumers have complained to a business about the risks of the processing, that probably triggers this issue. The retention requirement is we're keeping these reports for as long as the processing continues and 5 years after that, whichever's later. Next slide. For 5 years after the assessment, whichever is later. So we're keeping them for a bit of time. There are timing requirements for submission to the CCPA, which is facilitated via the CCPA website. For assessments conducted in 2026 and 2027, we have to submit no later than April 1st in 2028. So there's a bit of lead time to actually submit in both of those years. For those conducted afterwards, the submission deadline is immediately at the start of the year following. So in 2028, assessments done in that year must be submitted by April 1st of 2029. And there are certain things that you have to include in your submission, including the time period covered by the submission, by month and year, the number of assessments conducted or updated for each activity, whether the assessment involved the processing of each of the categories of personal information and sensitive personal information that's identified in the CCPA. So that's like the standard categories of data. And next slide. You are also making an attestation under penalty of perjury. The attestation's on the screen. But you're basically saying that I hereby declare that the risk assessment information is that I'm submitting is true and correct and complies with the regulations. And the person who makes that attestation is specified, so it has to be a member of executive management team. And the difficult aspects here are that the person has to be directly responsible for risk assessment compliance and has to have sufficient knowledge to provide accurate information, as well as have the authority to submit to the agency, the CCPA. So what we've found before in doing similar or meeting similar obligations with clients is that finding the person that is on the executive management team and has sufficient knowledge and is willing to attest to that can require some lead time, and as Kathleen and Danny mentioned, some education internally to make sure that people are comfortable to make these representations. The CCPA or the Attorney General may request a report at any time, and then you will have 30 days to submit that report. Next slide. So one piece of good news is that it's possible to combine risk assessments with other things and to combine them together. So where you have similar processing activities that present similar risks to consumers' privacy, they may be addressed in a single assessment. And the example we have is where a toy store collects kids' names, addresses, birthdays to mail them coupons and uses the same vendor across multiple stores. They do have to conduct a risk assessment because they're processing sensitive personal information, but they can use a single risk assessment because everything is being done in the same way. Likewise, if you've prepared a privacy impact assessment or similar report or analysis, you can actually combine that with this as long as you add in the specific requirements that this reg includes. And so there's no need to duplicate work, and you are able to leverage pre-existing work that you've done on technology and new processes, new processing activities, which is going to be great for for getting around to doing risk assessments everywhere you need to, and not ballooning the amount of work that's required for combining this activity or integrating it into your global privacy activity. Next slide. And that is it for risk assessments. Turning over to Kathleen for her session on cybersecurity audit requirements.
All right, so launching into cybersecurity audit requirements, we've got this section left, and then we're going to talk about consent management. We could easily spend an entire hour just on consent management. We probably could spend a whole hour on cybersecurity audits, but I want to make sure that we leave enough time to talk about consent management, just because there's a lot of current exposure in that space right now, and some pretty relevant updates to those rules. So touching more on the brief side here on the cybersecurity audit side, moving on to who is covered by this, who needs to complete a cybersecurity audit. Basically, every business whose processing of consumers' personal information presents a significant risk to consumer security needs to complete an audit. A significant risk exists when there's 50% or more of the business's annual revenue is derived from selling or sharing consumers' personal information. Or the business's annual gross revenue exceeds 25 million and they process the personal information of 250,000 or more consumers, or they process the sensitive personal information of 50,000 or more consumers. Moving from the what to the when, we're covering this now so that hopefully when you get to this point, you are not making a terrified face like these clocks are, anticipating this deadline. So the when is coming quickly, but we still have some runway here. The deadline for this is going to depend on the revenue. And so these requirements are being implemented in a tiered system. Businesses with annual gross revenue for 2026 of more than 100 million must complete their first cybersecurity audit by April 1st of 2028. There's a little bit more runway for everybody else. For businesses with between 50 million and 100 million, their first audit needs to be completed by April 1st of 2029. And then for less than 50 million, theirs don't need to be completed until April 1st of 2030. So following April 1st of 2030, if the business meets the criteria that require it to complete an audit, the business must complete the audit covering the next 12 months by April 1st of the following year. So for instance, if you were doing 3031, you would need to submit by April 1st of 3032. Next slide. All right, what needs to be included in the audit? There are a lot of things that need to be covered in these audits, and we did not attempt to touch on all of them here. There are several pages of information that need to be touched on. But at a high level, you need to include details of the business's cybersecurity program, an assessment of the business's establishment, implementation, maintenance, and enforcement of its cybersecurity program, an assessment of any of the applicable components listed in the regs. The regs can provide 18 components, most of which have various subsections, and allows the auditor to include additional components if applicable. So example components include things like authentication, including multi-factor authentication, antivirus and anti-malware protections, cybersecurity education and training, and many, many more. The regulations provide 10 areas that the audits must address, including things like applicable components assessed, corrections or amendments to prior audits, and what the information what the auditor is basing their assessment on. Moving on to interactions with the auditor and the specific requirements around the auditor. Every business is required to complete an audit must use a qualified, objective, independent professional who uses accepted procedures and standards. They may be an internal auditor. However, if it's going to be an internal auditor, you must follow additional regulations. Basically, there need to be safeguards in place so that that person is not part of what is being audited, that they are independently reviewed by folks that are not going to be impacted by the audit, and that their compensation is protected. So it really puts in place some safeguards around that person if you're going to use an internal person. The business must provide all information within its possession, custody, or control that's requested by the auditor that's relevant to the audit. They need to act in good faith to disclose all relevant facts and not misrepresent anything. The auditor must rely primarily upon specific appropriate evidence rather than attestations or assertions from management. I think this one is going to require a fair amount of legwork by the auditor, since they really need to be, digging into things themselves. The audit report must be provided to an applicable employee of the business with appropriate kind of oversight for ensuring implementation and correction of things that are raised in the audit. And the business and the auditor must retain all documents relevant to the audit for at least 5 years. And then moving on to the certifications that are required. The certification of completion, every year that the business is required to complete an audit, it must submit a written certification no later than April 1st. Importantly, the certification must be submitted by an applicable employee of the business who's directly responsible for audit compliance, has sufficient knowledge of the audit, and has authority to submit the certification. They need to include the business name, point of contact, statement that the business is concluded, the time period that's covered by the audit, and it must be including the electronically signed attestation of the form statement. So to Jana's point earlier, it can often be a bit of an undertaking to identify the right folks to participate in this process. All right, so moving on, Vince is going to cover consent management, both in the CCPA regulatory update and generally California Invasion of Privacy Act exposure in a fast 8 minutes. So good luck, Vince.
Thank you, Kathleen. Please forgive me if I speak fast. Hopefully my Northeast roots will help me here and I'll be able to get through this quickly. Next slide, please. So I think a good place to start is, what are cookies? What's tracking technology and what do they do? And so when we're talking about third-party cookies, these types of cookies don't just look at what you're doing on one web page or in one browsing session. They accumulate the data that you've gathered across multiple browsing sessions, across multiple web pages, and they create a picture or a unique identifier of a user with this information. They collect that information, they essentially create a profile of the website visitor so that when that visitor or that consumer revisits a website or goes to an entirely new website, that person is recognized. These cookies can track anything from the products you've viewed, the websites you've visited, products that you've added to your cart, even products that you've hovered over for more than just a cursory glance. And from that, they create a profile that can be shared across multiple websites, depending upon the ad networks or how you have enabled the cookies. But why is this a problem? The cookies create that unique identifier, and it's a piece of information that can track those browsing sessions, that browsing tendency back to a specific consumer. This is the exact definition of personal information that can be linked or that links back to an individual consumer. So cookie data is essentially personal data. And when we're dealing with personal data, we know that in many states, and with more to come, they govern how personal data is collected, how it's used, how it's processed. In many cases, when we're speaking about cookies, it's important to note the different categories or classifications of these cookies. There's oftentimes what we would call the necessary or functional cookies. These are the cookies that are strictly responsible for making sure the website operates the way it's intended. We have what you would more properly classify as analytic cookies. These allow the website to track how many visitors the website is seeing, how long these visitors are actually staying on a particular page, or what their tendencies are. And oftentimes these are used to improve the user experience, to improve website efficiency, and whatnot. And then lastly, and typically what these, what we'll talk about here in a couple of seconds, the California Invasion of Privacy Act lawsuits are directed to are the targeting and advertising or marketing cookies, which track your user behavior and then use that to redirect advertisements or other material that you may find interesting or that it believes you would find interesting back to you as you continue to browse online. Next slide, please. So in California and elsewhere, oftentimes what we're looking at is two overlapping but not necessarily coterminous regimes that govern consent management. So in California, for example, you have the CCPA, which is the state privacy level or the state privacy law that regulates how businesses use, collect, and process personal information. On the other side, you have these criminal and civil statutes that in many cases were based upon Soviet era wiretapping and eavesdropping statutes that are now being sort of reinterpreted or repurposed to cover online behavior and online tracking. Under the statute, the civil and criminal statutes, much like the California Invasion of Privacy Act, we have seen a massive increase in these lawsuits over the past several years. Unless you're living online, you've likely noticed a change in your website browsing experience. Each time you visit a website, many times now you are presented with a cookie banner. These were at least initially being driven in the United States by these CCPA lawsuits. Mind you, in Europe and under the GDPR, they had very much more specific regulations governing the use of cookies. These often, in certain instances, carried over into the United States. But the recent increase in cookie banner disclosures and consent management has been driven largely out of these lawsuits, particularly because it's not just these large tech companies that are bearing the burden of defending these lawsuits. Anyone who operates a website and utilizes cookies can find themselves on the receiving end of a demand letter or a recently filed lawsuit, and liability can be high. There is a private right of action under CCPA. It's there's statutory damages for $5,000 per violation. That's assessed on a per consumer basis and per wiretap or per eavesdrop. So as you can imagine, each time one of those cookies fires and collects that data and transfers it to a third party, you have a potential $5,000 exposure per consumer. It's not just in California. We're seeing these all over in places like Florida, Illinois, New York, and Pennsylvania. But in essence, if you operate a website that utilizes cookies, you may find yourself on the receiving end if you don't have the proper precautions and regimes in place to adequately address these concerns. Next slide, please. So again, not
Might
just
make sense to jump to the banner requirements since we've only got about 2 minutes left.
Sure. Yeah, we'll skip here. Sorry, thank you, Kathleen. I didn't realize we only had two. Are you thinking here or the last slide?
I was thinking the guidance around what the banner needs to look like and dark pattern avoidance.
Sure. Okay. Yeah, this is a good spot to jump in. Here we go. So part of the 2026 CCPA regulation amendments address dark patterns. Dark patterns are essentially any type of modifications to the user interface that would influence or otherwise modify the user's decision-making authority or ability to make an informed, fully informed, freely given, unambiguous choice. Then that's really what the definition of consent comes down to. When you're talking about dark patterns, the CCPA has provided both an advisory guidance as well as these new regulations, which largely mirror it, that provide some examples. So for example, requiring more steps to opt out of the sale or sharing of information than to opt in, that's going to be considered not freely given, unambiguous consent. Likewise, if you make the yes button more prominent than the no button, this can be both in size, color, shape, location on the website. If it's yes is prominently featured and you've got to search for the no button, that's also not going to be considered consent. Another one common that we've seen in the past is providing the user the option simply to X out of the consent banner without actually having to affirmatively select I accept. In that case, the act of Xing out of the banner without an affirmative choice is not going to be considered consent. We briefly touched on this earlier, but when it comes to financial incentive programs, things like rewards programs or loyalty programs, under these new regulations, you cannot select by default the opt-in or feature it more prominently than the option to opt out. Lastly, creating a sense of urgency, kind of that used car salesman, we've got to do it now. In terms of timing, that's also not going to be considered a freely given, fully informed, unambiguous consent as is required. Next slide, please.
And I think probably in wrapping up this section, we should just highlight that one of the changes under the regs are that you do need to provide a message that acknowledges whether or not a user has submitted a request, a do not sell or do not share request. And that can be something that's like a message on the site that says, we have previously received a do not sell from this IP address, something along those lines. So that's a new requirement in addition to these kind of more balanced symmetry things. And I think we're at the top of the hour now, so like wrapping it up, we're going to jump to future considerations, preparing your business for the future. We'll let Yana give a minute or two here and let you all go get back to your days. Yana, I think you are on mute.
Nice. There are a lot of moving parts, as Kathleen had mentioned, and as we've covered today. This regulatory framework really shifts California compliance out of kind of reactionary and more into a proactive space. And so you're mapping your data, you're standing up new processes, you are updating your notices within your global framework if you have one. If and if you do anything outside of just California, you definitely have a global framework or need one. And you need to work with a lot of third parties and ensure everything that you represent to the outside world actually matches what's actually happening in your systems. So really, we offer a few things. We offer some privacy user experience audits to help with the areas that are of regulatory focus, so that we've seen have been a regulatory focus and enforcement, and guidance on how to do this without going too crazy and wondering, why does your strawberry weigh less than a roll of tissue paper? And really systematically approaching this to leverage what you already have in place in your global privacy framework to make sure that you're meeting these requirements in time and under the schedule that's set out. Thanks everybody for joining us, and reach out if you need help with that. And here's the CLE code.
And I think we're supposed to read the CLE code, which is S as in Sam, 2011. So thank you all for
on
joining
the
us.
screen. If you're not listening, sorry, if you're not looking, scan it on the screen. SS 2011.
Thank you all for joining us. Have a great afternoon.